Hey guys, welcome to the Liberal Hive Mind, a channel solely focused on exposing the abundant hypocrisy of the left. Folks, the Democrat establishment is in full-on panic mode. 5-alarm fire throughout the entire Democrat Party's political machine. And trust me when I tell you they are panicking for good reason. For decades here, Democrats have essentially rigged House seats by using race-based gerrymandering under Section 2 of the Voting Rights Act. That's what we were speaking about yesterday. Basically, it's a law that allows them to create segregated districts based on skin color, specifically only for black people. And of course, knowing the voting patterns of certain demographics, that essentially allows them to carve out guaranteed Democrat seats in every single state, even deep Republican states. And all of this has been advertised under the guise of, quote, voting rights. It's essentially a vote-grabbing total scam, but now it seems like the Supreme Court is ready to blow that entire vote-grabbing racket to pieces. Oral arguments in this case happened yesterday, and holy moly, how do I describe this other than it was a complete bloodbath? And it's not just me saying that. No, it seems the left-wing establishment knows it as well. At least that's what I'm getting from this Politico article that seems to admit it. Let me show you guys exactly what's going on, and then let's delve into some of the arguments. We got some stuff to get into, so let's roll the tape. Alright folks, so like I said, Politico basically admitted it. Take a look at this headline right over here. Conservative justices seem poised to weaken Voting Rights Act. Several of the court's conservatives appeared hostile to the traditional understanding of the civil rights law. Let's read a little snippet from the Politico report. Justice Clarence Thomas, Samuel Alito, and Neil Gorsuch appeared inclined to bar virtually any use of race in redistricting. They suggested that race-conscious district lines might be unconstitutional, and Justice Brett Kavanaugh, whose vote will likely be pivotal in the case, repeatedly suggested that race-based remedies under the Voting Rights Act should be permitted only for a, quote, limited period of time. They should have an endpoint, Kavanaugh said during the oral arguments, which stretched for about 2.5 hours. Kavanaugh's desire for a time limit resembled the Supreme Court's treatment of affirmative action in higher education. 2 years ago, the 6-justice conservative majority overturned decades of prior precedents and struck down race-conscious admissions policies, more like race-based admission policies, discriminatory admission policies, in part because the court found that racial dynamics in society have evolved. Absolutely true. Chief Justice John Roberts and Justice Amy Coney Barrett, the other key votes, asked questions of both sides but were harder to read, and so essentially it's not looking very good. It's looking at a minimum that 4 conservative justices have already made their mind. They're essentially calling for race-based districts to end, and so now if one more conservative justice sides with them, well, this thing is over. Plus 19 seats for Republicans. And I gotta tell ya, if I was a betting man, I'd bet this thing is done and dusted, just like affirmative action. And what's really got me confident in saying that is just how brutal the oral arguments were. The leftist lawyers arguing their case got absolutely humiliated. I got a couple moments here. Let's start off with this one.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
So that's the NAACP's lawyer, and she's essentially saying that the law must remain in order to artificially boost black representation in Washington, D.C. Now, of course, you could argue that, yeah, that's the whole point, but don't you find that unconstitutional? Isn't it some sort of racial electioneering to set up a situation that explicitly gets particular people of a certain skin color elected to Congress? Imagine if you said the same thing, but in the opposite. Oh, well, black Democrats aren't voting for white Democrats, therefore, we need to draw districts specifically around white people so they can elect more white representatives. I get where this comes from, but in 2025, I find this method of thinking so entirely unacceptable. This obsession with race, you shouldn't be voting for people based on their skin color, but rather on track record and policy. And really, if you think about it, if this policy was so good to begin with, if it was so necessary for the advancement of black people's interest, then why have things gotten worse? You got black districts, black cities, where they only elect black people to power, black Democrats. And for decades, what have we seen? Failing schools, unsafe neighborhoods. I mean, complete disaster. Maybe it's time to move on and draw districts that are identity neutral, allowing the actual best candidates to start winning rather than forcing racial electoral outcomes. But then let's move on to the next moment. We've got literal genius Ketanji Brown Jackson, who made this argument.
I guess I'm thinking of the fact that remedial action, absent discriminatory intent, is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system. They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open.
So she's essentially making the argument that minorities need special race districts because they don't have equal access. And she makes a comparison to disabled people under the ADA. Are you freaking kidding me? Talk about the soft bigotry of low expectations. This is how they actually view Black Americans, as helpless, dependent, inferiors. It's 2025. Everybody has equal rights. There's no unequal access, regardless of what neighborhood you grew up in or the color of your skin. If you want to vote and be politically involved, you can do so. These laws or these special constitutional carve-outs are totally unnecessary. Then let's move on to the next moment. We've got Justice Sotomayor getting brutally spanked.
Reason to think that a racial group is being treated
here too. You have proof of that here.
No, you don't. What you have here is that Republicans and Democrats are different. There's no
you have some that even white Republicans or white Democrats won't vote for Black candidates.
Right, but if these were white Democrats, there's no reason to think they would have a second district. None. And so what is happening here is their argument is because these Democrats happen to be Black, they get a second district. If they were all white, we all agree they wouldn't get a second district. That is literally the definition of race subordinating traditional principles.
So again, the same argument. Well, white Republicans and white Democrats won't vote for Black candidates. Therefore, again, the argument is that I guess the Democrat Party deserves the right to be able to racially engineer their own seats. It is patently absurd. Then we have this last moment where, I might struggle to pronounce this name, Benjamin Aguinaga, anyways, Louisiana's Solicitor General. Well, he gives some insight into exactly what's going on here.
What role did Robinson play in the development of SB 8?
Justice Thomas, Robinson is the only reason SB 8 exists. We fought tooth and nail in the Robinson litigation itself in telling the courts that we did not think the Constitution permitted us to draw a second majority Black district. As you know, under protest, we drew SB 8 because the threat was that the federal courts were going to do it if we didn't. And that's, I think that's the best way to conceive of why SB 8 exists. We would never pass SB 8 in the first instance without Robinson, Justice Thomas.
What were the findings in Robinson?
The finding by the Middle District in Robinson was that the plaintiffs in this case were likely to show a violation of Section 2, and the likely violation, and I'm using very broad terminology because I do not know what the underlying violation is. I can't articulate that for you, Justice Thomas, because I don't think anybody can. But I think the finding in the district court's mind in that case was that the likelihood of a Section 2 violation meant that a majority Black district was required, a second one. And I think that was the bottom line, and when our legislature saw that, we understood the marching order, and that's why you see SB 8 as it exists today.
Just briefly, what were the findings that led to that conclusion?
Well, Your Honor, running through the preconditions and the totality of the circumstances, I think the totality of the circumstances did most of the work for the Middle District in Robinson. Senate Factor 1, the official history of past discrimination, Justice Thomas, we can never outrun the bad era of poll taxes, of grandfather clauses, of literacy tests. I think we're always going to lose across the board on that kind of analysis, and that's what the Middle District in Robinson focused on, is how bad was Louisiana in the 1930s, 40s, 50s, 60s, and, add all that together, and at the end you have a vote dilution finding that I don't think is clearly articulable in the way that SFFA requires a finding of discrimination to be specified.
You essentially have left-wing legal groups that are blackmailing states to draw districts that are favorable to them that will elect Democrats. In other words, they're engaging in lawfare, abusing Section 2 of the Voting Rights Act to strong-arm these states into giving them more representation. And again, what comes to mind is that it just seems wrong. It's racial electoral engineering. You know, maybe in the past, Section 2 of the Voting Rights Act was created with good intent, possibly. But today, it's obviously nothing but a Democrat power grab. The entire intent was to help black voters, right? But if anything, what it really did was trap them in race-based politics. It carves out these supposed black districts, and basically, the message is to black people that you vote here and other people vote there. That seems like political segregation, and it treats racial groups as individual monolithic voting blocks instead of actual individuals and actual individual citizens with independent thought. In these cases, the political power of these districts is not based in the interest of all Americans in that community all under one flag, but rather based on race. And frankly, I think that creates the theater for politicians to take advantage of black voters. Instead of earning the vote, you get to just grift your way to the vote by raising up your fist and doing your best Al Sharpton impersonation. Then, of course, you have these politicians who just play this theatrical, performative game, but they don't actually deliver results. They don't fix the schools, they don't stop the crime, they don't bring in jobs, but still, time and time again, it's guaranteed they're going to get 90% of the vote. It opens the door for race-based manipulation, race-based politics that doesn't empower anyone except for the people who are willing to abuse it and, of course, the Democrat Party. It creates a situation where corrupt politicians get to control communities while giving really nothing back in return. I think the whole idea of Section 2 was that it was supposed to uplift the black community, but in so many ways I believe it's freezing progress. It's divided people by skin color and told them that you're supposed to vote based on your skin color. It's plantation politics. And now it seems like this whole idea of racial election engineering, well, it might be coming to a burning, crashing end. And that's got to have the Democrat plantation owners blowing a damn fuse behind the scenes. Anyways, that's what I got for you guys. Thanks for watching, and I'll see you on the next one.